Good morning, viewers. Welcome to Consumer Shorthand classes. This is 120 words per minute speed and legal dictation passes 42. Get ready for dictation. 5 seconds. Start. Apart from above, it is required to be noted that the office premises of the applicant were already searched and relevant documents and material is seized. Such other adverse evidence against the applicant as was found is already sent for forensic audit, and that being so, it appears that for the purpose of investigation, further detention of the applicant cannot be said to be warranted. Apart from above, it can be inferred from the record that properties were purchased in the name of Messrs. Soros Marketing and Trading Company, which is a proprietary firm of the father of the applicant, that is Sunil, who is claimed to be main culprit or kingpin in the investigation in question. Since the applicant is a partner of Messrs. Soros Marketing and Trading Company, along with his father, who is absconding, that is Sunil, to some extent, it can be inferred that there is a certain overlapping of the interest with the main accused Sunil in operation of the firm, with Messrs. Soros Marketing and Trading Company, applicant being partner to the extent of. However, that by itself will not preclude the applicant from claiming bail, particularly when he has already suffered detention for 4 months and charge sheet against the applicant is already filed. This court is required to be sensitive to the order passed by the apex court in the above SLP, wherein issue canvassed by the applicant as regards police remand was dealt with. The apex court has held that prayer for bail of the applicant is required to be decided without being prejudiced by the observations made by the division bench in the matter of deciding the issue of remand, as observations therein are restricted to the extent of police custody remand only. The rigging of the auction process of the properties of the society which is under liquidation primarily appears to be at the behest of the firm of which father of the applicant, who is Sunil, is a proprietor, as is demonstrated by Mr. Harish, the learned senior counsel. As such, there is sufficient material to infer that the firm of which the applicant is shown to be a partner prima facie cannot be said to be involved in the commission of crime, whereas the firm of which father of the applicant is a proprietor appears to be involved in the offense. Even if the father of the applicant is a co-accused and is absconding along with other accused persons, that by itself will not disentitle the applicant to claim bail. This court is sensitive to the issue of taking out proceedings under Section 83 of the CRPC for attachment of the properties of the father of the applicant, viz. Sunil. In the aforesaid backdrop, in my opinion, case for grant of bail is made out. As such, the following order is passed. Order 1. Applicant is directed to be released on bail in crime number 673 of 2020, registered with Khadke Police Station, Pune City, on executing PR bond of rupees 1 lakh with one or more sureties in the like amount. 2. Considering the nature of offense, investigation carried out, statement of witnesses, request of the learned special public prosecutor that the applicant be ordered to be kept out of state of Maharashtra is accepted. Since the father of the applicant, that is the main accused, is absconding, the prayer of the special public prosecutor to keep the applicant out of state of Maharashtra is very much justified. Accordingly, applicant is ordered to stay out of Maharashtra. However, it is clarified that it shall be open for the applicant to move for modification once his father is arrested or surrendered in the crime in question. 3. Applicant shall furnish his address of his residence along with contact numbers, including landline number, to the investigating officer within 24 hours of his release. 4. Applicant shall directly or indirectly not influence any witness or tamper with the evidence. If so noticed, it is open for the prosecution to move for cancellation of bail straight away before the High Court. Applicant shall also not contact any office staff directly or indirectly as the investigation in the crime is still going on. 5. Applicant shall attend the investigating officer as and when called in the matter of cooperation in the further investigation process. The learned special prosecutor fairly concedes that applicant will be given 24 hours notice before his presence is required in the matter of investigation. 6. The applicant is permitted to furnish provisional cash bail security for a sum of rupees 1 lakh for a period of 4 weeks only in lieu of surety. That's all.